But along sort of the legal lines, we have a couple questions here from member Will, who one asks about the Supreme Court and the state of fully automatic firearms. He asks, is there any chance that the Hughes Amendment gets removed by the Supreme Court or by legislation, he asks. And he's basically asking, what's the upper limit of a hardware ban? What do we think the upper limit of a hardware ban will be under the current iteration of the Supreme Court?
Well, I think the first question is pretty easy to answer based on the bump stock ban oral arguments. We'll have to see what they actually rule in that case. I actually, we've done some members' pieces on this, but I think there's still a good chance that the bump stock ban falls, mainly around, the technical definition of machine gun. And this is kind of what the whole case seems to, in their mind, come down to that question of whether or not the bump stock actually fires more than one round off a single function of the trigger. And I think it straightforwardly does not, but the court was not as sure on that question. But either way, one thing they were quite clear on, I think even a number of the conservative justices, I think Gorsuch and Barrett both just explicitly said that they thought bump stocks should be banned, or that they would sympathize with banning them. Their main problem was, again, whether this ATF interpretation actually fit the law and the way it's written. So they didn't really have a question about whether they could be banned. Now, maybe the court would have a different tact if this was more of a Second Amendment case, because this case was not. It just isn't a Second Amendment case at all. In fact, Kavanaugh asked the bump stocks plaintiff, the lawyer for Cargill, the plaintiff in the case, whether or not, or really why they didn't make a Second Amendment claim. And Cargill's lawyer just said that, that they wanted to keep the case focused because SCOTUS doesn't usually like to go outside of the question presented into other, theories or areas. And also that they didn't have a clear understanding of the court's feeling towards dangerous and unusual weapons, and whether they would fit a bump stock in that exception from Heller. But yeah, if you're listening to that oral argument and wondering about whether or not the Supreme Court's going to strike down the Hughes Amendment or the NFA as a whole, I think the feeling you would get is that they wouldn't do that.
Yeah.
And I think that fits pretty well with how the court operates in practice, right? We've talked about this in the past. You could read Bruin, and you could read the standard that they've set up in Bruin, this history and tradition standard, and look back at the founding period and say there weren't very many gun laws at the founding period. So therefore, this standard could be used to strike down most gun laws that exist today at the state and federal level. And I think that would be a pretty fair reading of the ruling and the standard, but one that ignores the practical way that the court goes about handling Second Amendment cases, and really kind of all cases to some degree. You could kind of see this in even the recent Colorado ballot access case for former President Trump, where it was a 9-0 ruling. And even if you read the text and think, well, this should have applied, even if the justices might have thought that in some sense, it's just so unlikely that this court would step in and take, drastic action like removing somebody who is currently leading the race for president from ballots, or allowing states to do it at least. And I think you have to take somewhat of a pragmatic approach to their gun jurisprudence as well. And this comes through a lot in Heller, especially, where they're, it's not binding, but in dicta, they make a lot of exceptions that don't make a lot of sense with what they'd ruled, right? Like the machine gun aspect, they specifically call out M16s in Heller as not affected by the ruling. And I think they would probably stick to that for now, at least, the makeup of this current court. And you can look at the way that they've applied, the way that they've taken Second Amendment cases. they're not taking front running cases. They're taking cases where the public's view of these things has already solidified years earlier in favor of expanded gun rights. So Heller came in 2008. Well, in the 1960s, there was quite a lot of public support for banning handguns, if you look at the polling. But by the time you got to 2008 and, on through today, public support for that had cratered to almost nothing. And there were really only like 2 laws in the country that actually banned the possession of handguns. One was in Washington, D.C., and one was in Chicago. And the court took both those cases and ruled against the bans. These were novel outlier laws that the court went after. And you could say the same thing about Bruin. Bruin didn't happen in 1990 when most states banned concealed carry outright. It happened in 2022 when no states banned concealed carry outright, and there were only 8 states that still had these May issue laws that made it very difficult for anybody, a normal person, to get a permit. And so they're doing these things way after public opinion had already shifted in that direction. And so when you look at machine guns, you haven't seen that kind of public perception shift. And I don't think the court is going to go out there and strike down extremely popular gun restrictions at this point.